Okay, so just to point out, this is when it says maglev, M-A-G-L-E-V, that stands for magnetic levitation. So it's more or less the system we saw yesterday with the Hyperloop. The train moves on a magnetic force, on a magnetic field, and it levitates. It does not touch the rails. This is a technology that is amply used already used in high-speed trains in Japan, and this technology now has been imported in China, and the aim is that of traveling more or less at 600 kilometers per hour. What does this mean substantially from a technological point of view? It means that if you are building new infrastructure, rail infrastructures, you think that instead of having you'll always have rails, because you need rails, because if the train slows down, it just goes down on the tracks. If for any reason it has to slow down, and so, but this has it is less complex than a Hyperloop, because the Hyperloop travels in a vacuum, and therefore you need something that is completely closed, a tunnel that is closed, and is much more complex from an engineering point of view. While here we would have a traditional railway, although based on instead of having wheels that go round, it just simply goes. It is magnet, and the magnet pushes the train ahead. Just to point out that, and when you travel at 600 kilometers per hour, well, that is the speed of a propeller aircraft, not really a jet. Jets generally go 800, 900 kilometers per hour. 600 kilometers per hour is more like a propeller or a small jet. But anyhow, it shows that you can travel great distances very fastly. I mean, 600 kilometers is the distance more or less between Rome and Milan. It's 500 kilometers. That would mean less than 1 hour to go from Rome to Milan. And you can imagine in France, traveling 600 kilometers is well beyond Lyon. It's getting pretty near from Paris to Marseille. So it gives you the idea of the relationship between speed and time. People want to travel, and the shorter the travel, the more people will use that mode of communication. It shows that there's a very strong competition between various modes of transport. As you see, airplanes, trains, hypothetically hyperloops in the future, and obviously technology brings a regulatory, at least especially in the European environment, brings a complex environment, regulatory issues, and obviously also on questions of safety, of protection of passengers, and so on. So just to show you that the maglev is already a reality in Japan, and in China, although we're still speaking of trains that go around 350 kilometers an hour, but the idea is bringing them to 600, which is considerable reduction of time of transport. Having said this, let's move on to the presentations. And so if Galea can do her presentation.
Yes. Okay.
Yes. You must widen the screen because we only see part of the slides. At least I see only part of the slides. I don't know if apparently.
Let me see what's happening, because
you must put it on the screen and then you open it.
Yes.
When you share screen, you open the file. At least it should be.
Is this okay now?
Yes, here we are. Fine, okay. Fine. Nice, a fascinating train yard. This is sort of these wonderful places that when the train passes, we say, "What is this?" And well, this is a train yard. Go ahead, Claire.
Okay, so this case is a German one. It is the applicant is CTL Logistics and the defendant DB Nets. It was decided after a preliminary ruling by the Court of Justice of the European Union very recently on the 9th of November 2017. Now, the facts of the case are the following. So, the applicant, which is CTL Logistics, is a private railway transport company. On the other hand, the defendant is an authorized public undertaking. So, this is not a monopolistic situation. Now, CTL Logistics utilizes the railway infrastructure of the defendant, DB Nets, and in turn, CTL Logistics paid the train path prices to the defendant, DB Nets, which were established by DB Nets independently, so CTL Logistics did not have a say in relation to this list. As from 2004 until 2011, CTL Logistics paid accordingly. However, later on, the applicant applied for the reimbursement of this charge. Now, the conflict between these parties arose due to the cancellation and modification charges which DB Nets unilaterally included in the train path price lists, and which applied whenever CTL Logistics sought to modify or cancel a previously booked-in train path. CTL Logistics implied that those charges were unreasonable and established by one party only. So therefore, as a reaction, the applicant brought an action at the Regional Court of Berlin in Germany against DB Netz. And the German Regional Court tried to analyze the value of their national paragraph 315 sub-article 3 of the German Civil Code. And it stated the following: where the specification is to be made at the reasonably exercised discretion of a party, the specification made is binding on the other party only if it is equitable. If it is not equitable, the determination shall be effected by judgment. So therefore, the matter shall be taken to the German Civil Court. Now, the German Regional Court referred to the Federal Court of Appeals jurisprudence and maintained that the civil court in Germany had the authority to analyze the fairness of DB Net's train path prices. And these prices had been set up by the railway infrastructure manager. Now, when this case is going to be referred to the Court of Justice of the European Union, we shall see how the Court of Justice of the European Union shall analyze this role of the infrastructure manager. Now, the German referring court had a main query, and this was whether it was possible to examine equity in terms of paragraph 315 of the German Civil Code and include Directive 2001/14 simultaneously. So here we see sort of a clash between their national law and a European Union directive. Now, the referring court opined that this was not possible since paragraph 315 of the German Civil Code assumes de facto a regulatory function, which is not compatible with the principle of reference to a single regulatory body pursuant to the first sentence of Article 30, Subarticle 1 of that directive, and which does not take sufficient account of the principles set out in that directive concerning the calculation of the charges for the use of the infrastructure. So therefore, the German Regional Court conducted a preliminary reference to the CJEU, and it asked 7 lengthy questions which were later reformulated by the Court of Justice of the European Union into the following question. And the question was whether the provisions of Directive 2001/14, in particular Article 4 sub-Article 5 and Article 30 sub-Article 1, 3, 5 and 6 thereof must be interpreted as meaning that they preclude, so therefore they do not include, the application of national legislation, such as that at issue in the main proceedings, which provides for a review of the equity of charges for the use of railway infrastructure on a case-by-case basis by the ordinary courts, and the possibility, if necessary, of amending the amount of those charges independently of the monitoring carried out by the regulatory body provided for in Article 30 of that directive. So therefore we see that if paragraph 315 of the German Civil Court is applied, and the German Civil Court shall decide whether those train path charge prices are fair or not, it is to be done on a case-by-case basis. Now, the Court of Justice of the European Union pointed out the principles of this directive, and then it interpreted them in light of this case and how these aims were either contradicted or pursued by national German legislation. So first we shall have a look at the objectives of this directive. So recitals 5 and 11, they guarantee non-discriminatory access to the infrastructure. Recital 16 assures fair competition, especially when it comes to charging and the capacity to allocate schemes. So the infrastructure manager must be independent. Recital 12 rules the efficient use of the railway infrastructure by assisting the infrastructure manager in ameliorating the use of their infrastructure within their framework. Pursuant to Recital 20, in order to reach this aim, the figure of the infrastructure manager must embody a certain degree of flexibility. For instance, according to Recitals 34 and 40, the infrastructure manager should be given incentives for investment in railway infrastructure. Now, in order for these objectives to be reached, Recital 46 orders the creation of a regulatory body, ensuring the application of EU rules, and acts as an appeal body. This appeal regulatory body encompasses the efficient management and fair and non-discriminatory use of railway infrastructure. Member States have the responsibility to establish this body by virtue of Article 30 sub-Article 1 of Directive 2001/14. According to Article 30 sub-Article 2 of this directive, the applicant can appeal here in the case of a discriminatory decision by the infrastructure manager. So this contrasts what Article 315 says, whereby the German Civil Court has the discretion to discuss such matter on a case-by-case basis. Article 30 sub-Article 3 ascertains that charges made up by the infrastructure manager must be non-discriminatory. Additionally, negotiations between applicants and the infrastructure manager concerning the level of infrastructure charges are permitted only if they are carried out under the supervision of the regulatory body, which is to intervene if negotiations are likely to contravene the requirements of that directive. Also, Article 30 sub-Article 5 of the directive rules that this appeal body has the discretion to decide and grant remedies in 2 months. Its decisions should be binding on all parties. Therefore, unlike paragraph 315 of the German Civil Code, decisions would not be on a case-by-case basis. In addition, Article 30 sub-Article 6 of the same directive asserts that its decisions are subject to judicial review. Now, the interpretation of paragraph 315 of the German Civil Code by the referring German court. The principal aim of this paragraph is that of rectifying those unreasonable services. And the German courts interpret the German railway legislation, namely the provisions of the AEG and EIBV, which transposes Directive 2001/14, as meaning that it does not preclude a review in the light of civil law on the basis of paragraph 315. Now, paragraph 67 of the judgment said the following. So, such an action would necessarily entail a review of the charge set by the infrastructure manager and, if necessary, a reduction in its amount after an assessment of its fairness, while such an effect would be uncertain as regards decisions taken by the regulatory body. The following paragraph asserted that, according to that case law, paragraph 315 of the German Civil Code may be applied even where the charges are set in the form of a general tariff, given that the legal relationship between the railway infrastructure manager undertaking and the rail transport undertaking is governed for the purpose of civil law by paragraph 14 sub-article 6 of the AEG. The AEG is a German national legislation. Now, the findings of the Court of Justice of the European Union. Essentially, the court makes 7 main points which reach the ultimate decision of the same court. So the first point was, so when the notion of fairness is examined on a case-by-case basis, it goes contrary to the principle of non-discrimination, which is found in Article 4 sub-Article 5, as well as in Recital 11 of Directive 2001/14. Hence, the review of equity, according to paragraph 315, hinders the possibility of attaining the objectives of this directive. The second point, Article 4 sub-Article 1 of the directive creates the so-called charging framework by the respective member state and ensures the autonomy of the infrastructure manager. The infrastructure manager has the discretion to set out the charge for the use of the infrastructure. Hence, the civil court's discretion granted by virtue of paragraph 315 goes counter to the aims of the directive. Also, Article 8 sub-Article 2 states that the manager must be in a position to set or to continue to set higher charges on the basis of the long-term costs of certain investment projects. The third point was, the usage of the material assessment criteria pursuant to paragraph 315 of the German Civil Code can be inconsistent with Articles 4, 7 and 8 of Directive 2001/14. Secondly, when the civil courts apply national German railway legislation, they would impinge on the authority of the regulatory appeal body created by virtue of Article 30 sub-Article 1 of the same directive. The fourth point was the following. The principle of non-discrimination is hindered once the undertakings have to resort to the civil court, which will decide accordingly. It is only through the civil court that the case can be intervened by the Supreme Court. Also, the review of equity pursuant to paragraph 315 includes an analysis of the charge set up by the infrastructure manager, which can be altered by the civil court in order to prohibit discrimination, and this does not abide by the principles of the directive. The fifth point was that according to Article 30 sub-Article 5, Those decisions taken by the regulatory appeal body established by virtue of Article 30 sub-Article 1 are binding on all parties. Pursuant to paragraph 315, only the parties involved in the dispute would be bound by the decision of the German Civil Court. Hence, this is another reason why it does not conform with the objectives of the directives. The sixth point was that there might be an amicable settlement without the involvement of the regulatory body, and this precludes the obligations listed under Article 30 sub-Article 2 and 3 of the directive. And paragraph 315 of the German Civil Code is not compatible with one of the primary objectives of the directive, that is, infrastructure managers should be assisted and supported to utilize their infrastructure. So even if application of paragraph 315 of the German Civil Code allowed the specific objectives pursued by Directive 2001/14 to be taken into consideration, there would be a clear risk that the reduction on a case-by-case basis of the charges would give rise to discrepancies as regards the incentive effect achieved, and that railway transport undertakings would be encouraged to obtain by civil actions advantages from which other undertakings in a similar situations do not benefit. And finally, the decision of the Court of Justice of the European Union was the following. So keeping all these points in mind, it decided that Article 4 sub-Article 5, Article 30 sub-Article 1, 3, 5 and 6 should be interpreted in light of not including the application of national legislation. Hence, there could be no review of equity of charges for the use of railway infrastructure by a civil court, which in turn decides each case on its own merits. That civil court should not have the authority to change the charges in an autonomous way from the regulatory appeal body established pursuant to Article 30 sub-Article 1 of Directive 2001/14. So that was the presentation.
Thank you, Galea. Can you hear me?
Yes, yes.
I have a problem with my microphone. I'll just go out a second and I'll return because I have a small problem. The microphone of my laptop is not working well. So just
Okay.
1 second. I'll just go out of the room and I'll